Efren Santos v. King Chef / Marites / Joey Delos Santos, GR number 211073, November 25, 2020. Facts. King Chef is a Chinese restaurant owned by Ang, with Delos Santos as its general manager. 8. It employed Santos on February 19, 2011 and Salmasan on July 29, 2010, both as cooks. On December 25, 2011, Santos rendered only a half-day work without prior authorization. 10. Salmasan, on the other hand, did not report at all. 11. Petitioners claimed that in view thereof, they were dismissed from employment. 12. They averred that when they tried to report for work, their chief cook told them that they were already terminated. Accordingly, petitioners filed their complaint for illegal dismissal, underpayment of salaries, non-payment of salaries and 13th month pay, damages, and attorney's fees. Respondents denied that petitioners were dismissed from work. They argued that petitioners violated the December 22, 2011 memorandum informing the employees of King Chef that no absences would be allowed on December 25, 26, 31 and January 1 unless justified. 15. After petitioners failed to report for work on December 25, 2011, and returned the following day merely to get their share in the accrued tips, they allegedly went on absence without leave, AWOL, for the rest of the Christmas season. Respondents believed petitioners went on AWOL after they got wind of respondents' decision to impose disciplinary action against them for their unauthorized absence on December 25, 2011. 17. Respondents claimed that even before they could impose disciplinary action on petitioners, the latter already filed a complaint for illegal dismissal against them on January 2, 2012. Issues. Whether or not petitioners were illegally dismissed. Ruling. The petition is devoid of merit. Procedural matter. The resolution of this case calls for a factual determination of whether petitioners were dismissed by respondents, which factual determination is generally not allowed in a Rule 45 petition. 44. One of the exceptions to this rule is when the factual findings of the quasi-judicial agencies concerned are conflicting or contrary. 45. Here, considering that the findings of the NLRC and the LA are conflicting, we shall proceed to review their factual and legal conclusions. Substantive matter. Here, after a meticulous study of the records, we find that there is no substantial evidence to establish that petitioners were in fact dismissed from employment. Petitioners merely alleged that they were terminated by their chief cook and were barred from entering the restaurant, without offering any evidence to prove the same. They failed to provide any document, notice of termination, or even any letter or correspondence regarding their termination. Aside from their bare allegations, they did not present any proof which would at least indicate that they were in fact dismissed. There was no showing here that petitioners' absences were due to unjustifiable reason, or that petitioners clearly intended to terminate their employment. It does not suffice that petitioners preempted respondents by filing the complaint for illegal dismissal before respondents can impose disciplinary action. The operative act is still the employee's ultimate act of putting an end to their employment. Wherefore, the petition is hereby denied. The assailed decision rendered by the Court of Appeals in CH/R SP number 130662 is affirmed. No cost. So ordered. Principles.